Uh, Hello everyone. I'm Nidhi Bausha, Executive Director, TiE Nagpur Chapter. I welcome everyone to today's session under the series Impact Speaker Series on the topic Intellectual Property Rights and Innovation. The session is jointly hosted by TiE Nagpur and TiE Germany. I'm delighted to welcome and introduce our eminent panelist for the day, Shrivastha NS, Senior Engineering Director, Solutions Architect and Innovation, UNICEF. Daniel Herman, partner Bohemuth and Bohemuth, European and German patent attorney. Ms. Pooja Molikar. So we would like to share that Mr. Pankaj Porkar, due to some medical emergency, he could not able to attend today's session as a panelist. So we have with us Ms. Pooja Molikar, Examiner Patents and Design from the Office of Deputy Controller of Patents and Design, Patent Office, RGNI PM, Nagpur. And we have with us Mr. Nitin Sachdeva, President TiE Nagpur and Managing Director, Delaplex. So there are a few housekeeping rules for the day. I would request everyone, those who are not speaking, please keep your mics on mute mode. And we will be taking the Q&A, audience Q&A in the end. So I would request everyone, those who have the questions, please put in the chat box. And now I welcome Mr. Nitin Sachdeva to please take over from here. And like we always follow that the self-brief intro of all the panelists, eminent panelists. So we would like to start with you, Mr. Nitin. So over to you. And just give me a second. I'll be sharing a screen. So.
Thank you so much, Nidhi. It's an honor to be here with this August gathering here. And people from across the globe, from different chapters, from different corporations. We have people from UK, India, Germany, US, Singapore, India. So basically, this session is a collaborative session, what we are hosting today. Jointly, this session is hosted by TiE Nagpur and TiE Germany. And the speakers here are Daniel Srivastava and Pooja Molikar today. So a brief introduction, Nidhi has already given about the speaker. I'll start with my introduction. I'm a chartered accountant, a certified fraud examiner, and I'm running a software services company in India. And I have extensive experience in various business industry segments in different domains. So it's always said that you should be an expert in one, but unfortunately, I'm not an expert in any one domain. I'm still a learner here. So I'm here to learn from the speakers here today. And we would want Daniel to please introduce himself with a brief background about what he does and what is his core expertise are.
Thank you very much, Nitin. I should I wait for the slide?
Yeah, actually, I'm trying. There's some error which is showing up. It's there already on my desktop, but it's not able to. I'm not able to share. I don't know what's the issue. It's not showing in the place where it shows the screen impact and all those things. I don't know. It's showing the PowerPoint, but it's not. I'm not able to get that command.
You can give control to me. I can show it.
Okay.
We can see it now.
We can see now the PowerPoint.
Yeah.
Yeah, okay.
Okay, then I will introduce myself. Yeah, thank you very much, Nitin. My name is Daniel Herman. I'm a board member of TiE Germany. By profession, I'm a German and European patent attorney and a partner at a law firm called Bohemuth and Bohemuth in Europe. I advise startups, SMEs, and large corporations, both domestic and foreign, on matters of intellectual property, in particular patents. Due to my technical background, I usually work with companies in the area of computer-implemented inventions, direct to all kinds of software, medical devices, including digital health, and all kinds of physics, and help these companies to build up company assets and protect against competitors. I'm very eager and happy to be here. Thank you.
Great. Thanks for the introduction, Daniel. We are happy to have you here on board as a speaker today. Srivasta, can you please describe your key skills and we would like to know more about you.
Sure, it's my privilege to be here interacting with all of you. You can call me Shri during the meeting in short. So, about my background, um, as far as my education goes, I did my master's from Bharatadasan University and then from BITS Pilani. And after that, management program from IIM Calcutta. So I put all those logos there, but the order is jumbled up. So IISc is where I started my career. That is where I started as a trainee in their supercomputer center. And after that, I also worked for a short time at DBORG, which was a company started by Dr. Vikram Sarabhai, then Sun Microsystems, Dell, and then Unisys. Unisys is where I'm working. I'm responsible for IP and patents globally right now. When I say IP and patents, I want to clarify one thing. We have a entire ecosystem in Unisys, so I'm looking at from engineering perspective, based on my engineering experience, what is the capability that we need as a company and what is the culture that we need and what is the ecosystem that we need to develop so that we have a continuous inflow of intellectual property, including patents. And then from business perspective, how do we leverage those IP for business and strategic advantage? That's what I'm looking at. My background is that most of my career during the last 25 years have been in product companies developing products around technologies that make up the data centers. And I've also led groups where I've been responsible for people, processes, culture, including developing my own frameworks and methodologies. And during these experiences, I've been actively involved in a lot of innovation initiatives as well, sometimes leading them at different levels. The current initiatives that I'm very active with, Open Source India is a large conference that happens in Bangalore these days, but all over India. And I've been one of the advisory members for that. We have a countrywide initiative called Grey Cells, which is to keep people intellectually engaged and happy and challenged. That's what I lead in Unisys India. And I'm also part of the Unisys Patent Committee. And recently I joined the NASCOM Innovation Track. I look forward to contributing there. So for this discussion, since we already have Pooja from the India ecosystem perspective, then we have Daniel, um, who's um, who's involved with patents legally. I'll bring in engineering perspective in terms of how to create, protect, and enable or rather leverage patents when you develop products. And that's what maybe will be my value add. But I look forward to learn a lot of things in the interactions with you all. It's a great privilege. Thank you for having me in this talk.
Thank you so much, Sri. And one thing for the interest of the participants here, Sri had been a TiE chapter member earlier, and because of his other engagements, he moved out for a while, but now we are going forward to welcome him back again in the TiE fraternity. Pooja, we have Pooja Molikar from the government's side, basically for this session. So, Pooja, can you briefly introduce yourself?
Okay, thank you so much, sir. Basically, our HO was supposed to represent this particular panel discussion, Pankaj Borkar, sir, but because of some medical emergency, he is not able to come here, and I am here on his behalf. My name is Pooja Maulikar. I am working as an examiner of patents and designs in the field of biotechnology at IPO Mumbai. Now, I am a person who's a biotechnology person who has done her BTech and MTech in biotechnology. I had also been a faculty at certain instances before joining patent office. Here at RG and IPM, our role is to give a massive training regarding intellectual properties. So, apart from examination, we are also looking at training and awareness, taking lectures. Right from 1 hour to 2 weeks of exhaustive trainings are being conducted at RGNIPM Nagpur, which stands for Rajiv Gandhi National Institute of Intellectual Property Management. It is always stressed that in case you want to learn about intellectual properties in our Indian perspective, then please do visit RGNIPM's website where a lot of trainings are being conducted, not only at a public level but also at international level. Also, we're conducting a lot of trainings. Famous one being international trainings with WIPO, that is WIPO India Summer School, World Intellectual Property Organization, which conducts summer school on an annual basis with Indian Patent Office. Apart from that, there are various Asian countries and other patent offices which are doing collaborative program with patent offices, which are conducted through RG and IPM only. So this is a brief profile. I also look at accounts and administrative part of RG and IPM, but that is not a part of this particular session. So I think with this I should stop because there is a lot of thing which needs to be discussed in further panel discussions. So with this I stop my brief introduction. And I can be reached at poojavm.ipu@gov.in. This is my email ID.
Thank you so much, Pooja. It's an honor to host you here today. We have listened to your talk and the insights given by you earlier as well at the Women Pitch Fest launch event last year. And it's
Yes,
always an eye opener to know what all things your institute has in place for the budding entrepreneurs as well as established entrepreneurs. We really look
it's an
forward to
honor
a
for
great
us
learning.
as well.
Thank you so much.
Thank you.
So, with this brief round of introduction, I think we have set the stage properly. We welcome all the participants, all the TiE governing body members, TiE charter members, non-members, associate members here who have joined by giving their valuable time and thought that yes, this is a session which will give some common grounds for us to co-learn and excel together. So with this, I would like to start with short questions to be placed for the session. And in between, if any participant has a question, can feel free to post it in the chat box or as raise a hand, and we can allow the unmute option, and the participants can speak as well. Feel free to interrupt and interact wherever you feel appropriate. So, Daniel, starting with you, you have been a practitioner in this field of intellectual property rights. So, can you tell us some more insights about how many types of intellectual property rights that you regularly deal or are there at Europe and Germany specifically?
Yeah, thank you, Nitin. This is, I think, a very good starting point to identify what different types are out there. On the technical end of the spectrum, we have the patents, very important IP right, and the utility models, which you may call the small brother of the patents. And then we have what we consider non-technical IP rights. There's the trademark, which is supposed to protect names and symbols. And we have the design, which is supposed to protect shapes of products. Then we have the copyright, and we also have the so-called trade secret, where in Germany we have a dedicated law which was just put in place. So these are the main six types we have here in Germany and Europe and essentially all over the world.
Great, thanks. Pooja, can you share some insights about the patent filing process as well as the term for which the patents are generally granted in India?
See, basically, every patent office works on the same concept. and everybody are having their own way, their own acts, rules, regulations, guidelines, which are more or less the same. But if we have to talk specifically about Indian Patent Office, then we are having uh, very few conditions under which a patent applications can be filed and granted. Now when we come to filing, of course there are some basic stuffs which needs to be remembered, like we are having around 30 forms in the patent office, but with the mere filing of 5 basic forms, you can file a patent application in India. If you talk about the categories, then we have given a lot of concession to various categories. Earlier, it was like individuals, startups, and MSMEs were being considered as different categories. But as and when amendments are happening, they are being considered into one single category, where the meager fees of online filing is around 5,600 for a person to file an Indian patent application. Okay, and apart from that, it is also seen that grant procedure varies as you shift from one branch to other. It is not like, let's say in 2015, two different people have filed application. One belongs to biotech, one belongs to electrical. So the grant procedure is going to vary. There are certain working conditions which needs to be considered with respect to patent office. So there is a huge pendency in, let's say, in electrical or in computer science, whereas when you talk about biotechnology, chemical, and allied branches, there you get the grant really soon, because the workforce and dependency, and there are other working conditions also which lead to this. But of course the grant procedure varies, and with this thing, keeping this thing in mind, government of India is doing a lot of amendments nowadays. So expedite examination has started for those who feel that there is a lacuna in them getting the grant really soon. So they can very well take help of expedite examination. Benefit can be taken by them. So the grant procedure as well as the filing procedure is made really lucid in India, with the amendments being made in the recent times.
Perfect. Thank you so much for the insights. The government has definitely made it very easy and convenient as a process to be followed for the entrepreneurs today all across the globe. So we'll come back on the same point with Daniel after asking Sri that in the corporate Sri, what it takes to build an IP as per you, and what are the challenges generally the corporates face?
Okay, so that's a good question, Nitin. I'll answer based on my experience in Unisys and in Dell and in Sun. Incidentally, all the companies that I've been involved with so far have had a formal ecosystem with respect to patents. So when I say IP, like Daniel explained, there are different forms of IP way beyond patents. So even when you create something, like even if you say you write a line of code, you're actually creating IP. Or even if you, let's say, create a best practices document, you are potentially creating the intellectual property. And we don't necessarily protect all of that, but the challenges of building IP in corporates is to have the ability to recognize IP when you're creating IP, be cognizant of this is IP or this is not IP, and then think from an IP perspective, and then think of, are we protecting this IP? Suppose we need to protect something before we disclose it. Are we protecting it? And then how do we leverage it? Even when you develop a product, how do you leverage the intellectual property that you have created? Now, for creating IP itself, let me just take patents as an example because that is where most of the IP comes. If I go into the code, then we look at copyright. How are you protecting your code, and are you mixing other code with your code, and are you infringing on somebody's IP, or is your IP protected? That's a different area altogether. So let me just focus on patents. Now, even if I look at a patent in corporates, we have a complete ecosystem which is created because the sheer number of, let's say, people who work on the products, we try to keep them separate from the legal processes that are involved in filing the patent. So we have separate legal teams that take care of filing the patents. So the patent ecosystem is created in a way where, as an engineer, if you come up with an idea or if you think something is patentable, then there is a patent process where you can, let's say, fill up a form. And when you fill up a form, the form itself tries to bring out some kind of patent thinking in you, in the sense, are you creating something new? What is the problem you're solving? How is it different from others who are solving the same problem? Why do you think it should be patented? So the form itself kind of mentally primes them to think of, is this a patentable thing or not? And then we submit it to patent committees. There are patent committees who are kind of glue between the people who invent, the inventors, and the legal teams. And the patent committee is a good representation of multiple areas. And they do a good evaluation of, is this something that makes sense for us to file? And then the legal process takes over, where they work closely with the inventor to see how they should be filed, and that's a long process. At the same time, how do we create a win-win situation for the inventor and the company? There are other reward mechanisms. Maybe we can touch upon that future. I mean, further down in the conversation. But for an organization, it's very important to have an entire ecosystem, right from the point where you're creating intellectual property. Even if you don't call it intellectual property, when you're creating something, how are you protecting that? Are you conscious? You're not exposing that. Is it a trade secret? Is it a patent? And then have an entire ecosystem, including right kind of coaching, training, all of that, including rewards to take over. Hope that makes sense.
Perfect, perfect, perfectly. So it's not an easy process, even in big corporations. So it takes lot many efforts and inputs from various stakeholders to move forward. So for startups, we will come back to the same question specifically for startups, how important it is for them to safeguard the patents. And we would like to ask Daniel about the process for innovators or firms if they wish to apply for patents from India, and what are the patentable vis-a-vis the non-patentable items in Germany and Europe?
Yeah, thank you very much, Nitin. I will pick up where she left. So the starting point is, of course, that you have a patent application, and a patent application means description, claims, and figures. And the question is now, what should be in this patent application? What can be granted? What can be patented? And in Europe, I would divide the non-patentable subject matter into three categories. We have first, I would say, the bio area. The second is the medical area. And the third one is an area which mostly touches software, computer implemented inventions. So if I start from the back, in the area, if you are working in the area of computer implemented inventions, what is not patentable are things like a business method as such, a presentation of information as such, a mathematical method as such. But this is a very narrow area where things are excluded, because these are mere for presentation of information to keep the freedom of speech and journalism. So this is not what of course you have in mind when you file a patent application. And also with mathematical methods or business methods, administrative methods, these things are more really something you put on a sheet of paper and say, okay, I sell this product here, I do this process here internally in my company, and I have this kind of spreadsheet. So this is not really relevant in terms of patentable subject matter, because all of these things I've just mentioned, if they are implemented, so if they are in a software, embedded in a software running on a computer, it's patentable, because the patent office in Europe and Germany says the computer technology is technology, so it can be patented. But this is not the end of the story in this area, at least, because they will, under inventive steps, so for granting a patent, it must be patentable subject matter. The subject matter must be novel, and it must be inventive. And for the assessment of inventive steps, so if your invention was not obvious, the patent office then ask the question, is what is in your claim actually solving a technical problem with technical means? So even if you have a computer implemented business method, so to say, the patent office will ignore many of the features as more being of a business type and will then ignore these features during the assessment of inventive step. So just for you as an information, patentability in this area is not an issue. The issue is more on inventive step. So this was the first category. Now I move on to the second one, which is medical. In the medical area, what should not be patented is basically what the medical doctor, the physician is doing. So what is not patentable is methods of treatment, methods of surgery, diagnostic methods. So everything what the medical doctor is doing should be kept free of any patents. And this, of course, makes sense. And then the third category is the bio area. So I myself, I'm not a biologist. We have another one here, so maybe you can add to that. But what I can say is that in the bio area, of course, there are some things which are not patentable for reasons of morality. So cloning humans, of course, and using human embryos for any kind is not patentable. And also what is not patentable is plant and animal material, which is produced exclusively by essentially biological processes, which means to the area of crossbreeding, what the farmer is doing, this should be kept free of patents. And I think here is maybe to build a bridge to India. Here's the biggest difference, I would say, compared to India, because in my understanding is that in India, in the area of biotech, antibiotic cells and gene sequences, any material identical to nature is not patentable. Excuse me, while in Europe, this would be patentable.
Perfect, Daniel. Thank you so much for the detailed insights. We'll come back on the process and the barriers after a while. The other day I was speaking to Siri and he shared his inputs on the importance of registering and going for patent registration the moment you come to know about it, even before publication. So I would like to put forward this question to Pooja ma'am. Pooja, why is it important that the invention should be patented before publication or display in public?
It is actually understood that whenever you go for a patent filing, the information needs to be novel, and if not novel, it needs to be at least inventive in nature. Now, novelty means something which is not known to the public, general public, and it does not form a part of the general public domain knowledge. Okay, now when we talk about public knowledge, it includes anything and everything which has been known to the general public before you have gone for the patent filing. And that is where the concept of novelty comes into picture. Now, when you say the public does not know, it shouldn't be knowing in either of the form, like in published, presented, or otherwise disclosed. When we say publish, it is quite understood that it should not form a part of any journal, it should not be a part of any article, book, any of that sort which is known to the general public in a published format. There are certain groups which acquire certain knowledge or which hold certain knowledge in their own community. They do not disclose it to others. There are certain people who do not know, who are not literate enough to put their information in a documented format. So they tell others in the oral form of disclosure. Okay. Certain communities are seen to put their information in pictorial form. So any of these information will be a part of public domain knowledge which people have access to. It's not a information which is intact to a particular department, or let's say a research and development center, not of that sort, but anything which is known to the general public. Now, when we talk about novelty, and when we are saying that it should not be a part of prior art, it means that you are the first person to introduce that idea, and that is where your invention will be considered as novel. And that is the major reason why it is being told that you shouldn't be displaying your information in any of the public domain. there are certain provisions in which you can rectify this mistake, or in which certain relaxations are being given. But prima facie, it is always advisable not to fall into that trap, and not to make things really critical enough for you to justify at the later stage. It is advisable that at the beginning itself you do not do this mistake of putting your information in public domain. This is the concept of novelty. When we talk about inventive step, it is something different, where something is already there and you are trying to improve things over the benchmark. Like whatever benchmark has been set, you are improving it. So there, the question of prior art or prior information in the public domain does not affect that much the way it affects to the novelty of that particular invention. So why to do that mistake? It is always advisable not to put your information in the public domain before you go for patent filing. Once you do the patent filing, it is perfectly okay. From the very next day, you can go for paper publication. You can give articles. You can write, articles. You can give interviews. You can do whatever you want. You can even commercialize your stuff. Whatever you want, you can do, but not before the date of filing.
Perfect. So see, we were discussing about the importance to protect new research the other day. So can you share some insights about what is the need to protect new research, be it be for established corporations, enterprises, or young companies?
Yeah, that's a good question, Nitin, because many times research, it's like a chain. Research is closely tied to innovation, and then again you're looking at whether you want to protect it or not. What I would say is there are different ways you end up doing research. Sometimes do research as an individual or as a group. Sometimes you collaborate with others, and let's say whether as a corporation you're collaborating with academia or not, or whether you're partnering with somebody. Now, ultimately, you should understand that when we are collaborating or working with each other, it might lead to something new. It might lead to something which is very novel, like Pooja said, something which is a
हाँ सागर
non-obvious
जी
way of doing something.
बोलिए ना
And it should
नहीं वो
not
अपना
ideally
हो
be
गया क्या बैंक वाले को जो देना था
I would request that
अच्छा अच्छा
someone's mic is
वो
open. Could
मान
you
गया क्या
please, Mr. PV, could you please switch off your mic?
yeah.
I don't know. It's PV or someone else?
I'm so sorry. Maybe you can do this
अच्छा
from your
अच्छा
side.
साइन वाइन भी कर
Okay. So what I was saying is that when you go about your research, and when you go about it alone or as a group or in a collaborative manner with academia or with partner, most of the time the purpose and the possibility of finding something very novel is very high. So it's really important to think of, it's a thought process that matters. It's important to think of what do you want to do with the outcome of the research? What is the purpose there? If it leads to a new discovery or a new invention, then who owns that? Is it going to be you, or is it going to be a jointly owned thing? Most of these are legal aspects, so it's very good to be clear about it when you go about research. The way I look at it is, if suppose you need to go from a point A to point B, crossing a maze, research is uh, where you methodically eliminate 99 ways of not getting there and finding out what is the best path to get from A to B. Now, which means you spent effort eliminating those 99 paths. Like Edison said, I found out 900 ways where a bulb wouldn't work. So you eliminated those 99 paths, which means you need to protect the path that you took. Now, when I say protect, do you want others not to take the path? Then that becomes your trade secret. But do you want others to take that path and you get money every time they take that path? Then you're looking at patenting. Then, if you want a lot of people to take that path, you don't want others to patent it, then there are strategies where you don't want to patent something, you deliberately want to disclose it, make it, let's say, open source. Ultimately, when you do research and then closely link it to innovation, it's the thought process that matters. What do you want to do with the outcome? It's very good to be, or it's very beneficial to be very clear about whether you want to protect it, publicize it, or cross-license it, or what do you want to do with that work. I think as long as there's clarity, you won't deal with a lot of mess afterwards. That's what I would say. Hopefully that answered your question, Nitin.
Yes, that makes it pretty much clear for the organizations that at times, for business reasons, where the new startups want more number of people to use their platform or products, so they may make it open source and don't go for patents for each and every research. Be a business, be people who are based on business decisions, basically. This is what I understand. And the importance definitely you have showcased for new research registration. And Daniel, if I want to go for a patent registration, I know that it takes number of years as well at times. So whatever I am doing today, someone else could also be doing in Germany. So can I go for a expedited examination of the existing applications? And the same question I'll put forward for Pooja as well after Daniel.
Yeah, thank you. So this is a valid question. Both can be of interest. Accelerated examination, but also deferred examination. So accelerated examination at the European Patent Office, yes, there is a request you can file. It has a nice name, PACE. And if you file a request which has no official fee even, then the EPO will issue the next communication within 3 months. And so this is possible. You also don't need to provide any reasoning for that. In Germany, there's no formal request in place, but you can still ask the examiner, how long does it take? Can you pick it up earlier? You can also file such a request, but it's at least not, it's less formal. You more depend on what the examiner wants to do or does not want to do. If you look on the other end of the scale, deferred examination. Deferred examination, you might think, why should I defer examination? But actually, many companies, they don't yet know what the product exactly will be, how it will really look when it enters the market. You have the invention, you have an idea about how it works, but maybe there are still some options which you have described in your application, but you're not yet exactly sure which is the best one and which we will put on the market and sell. So especially this applies a lot in the pharma area. So you might want to defer examination. And there's a unique possibility in Germany. In Germany, we have the possibility to defer examination by 7 years from a filing date. So this is quite a lot, and it's unique. So it means you can file an application in Germany and have it sit there and activate it on whenever you want within these 7 years. You can even have it searched, so search for prior art without examination. So you first get an idea about the prior art. And in Europe, unfortunately, this deferred examination is not available. But what sometimes happens actually that from an international applications, clients file an application in Europe and in parallel in Germany and do not request examination in Germany and only activate this application if the European one doesn't work out. So you can play a little bit with the tricks. Here and there, procedural tricks are available in both directions, acceleration and deferring examination.
Perfect. Thanks for the inputs, Daniel. At times, it is better to differ as well, and thanks for discussing the deferral process as well. So in the interest of the participants' questions, we have 20 minutes. I would request the panelists here, if they can summarize their answers in 30 seconds to 120 seconds. Srivastav, this is for you. Process to safeguard the IP, trademark, trade secrets, and innovations.
Yeah, I'll try to keep it very short. There are multiple types of IP, like Daniel said. The way you protect those are very different. I'll not touch too much on trademarks because you already have a product and you want to protect that brand, and it's more of marketing and a legal combination that works there. Not my fault, but when it comes to, let's say, trade secrets, most of the times when you create products, when you create software, what are you doing uniquely that you don't want others to access? And when you have distributed teams, when you have partners, when you are doing collaborative development, how do you really protect your trade secret? That is where the strength of the controls you have in terms of who has access to what part of the code. Does anybody know how to build the whole product? Does anybody know all parts of the code and who's accessing what? The strength of your process determines how well your trade secret is protected. Some of us even have thorough vetting before we allow anybody to access the code, and everything is audited. And then when it comes to patents, of course, we spoke a lot about patents. How well you protect your patent, I mean, how will you protect your patents? That's a different ballgame altogether. But again, based on the type of IP, be it process or patents or any other method that you choose, there are ways to protect it.
Perfect. Thanks for the inputs. Pooja, the term of granted patents in
Yes, sir.
India, and the same question to you, is there any expedited examination process available for entrepreneurs?
Could you repeat your first question? I was not able to hear you.
Yeah, the term of granted patents in India, and
Okay.
can it be renewed?
Can it be renewed? Patents as such cannot be renewed because, of course, patent is given for a specific term period, after which it becomes a public property, and that means that you enjoy the monopoly for a certain period of time, which is actually 20 years of time from the date of filing. Now, when you say date of filing, it varies with respect to international applications and Indian applications, but then either the priority date or the first date of filing, that is the first filing date, is being considered for calculating this 20 years of term period for a patent to get
Pooja, your voice is cracking a little.
to enjoy
Is it me? Yeah.
the monopoly.
Pooja, your voice is cracking a little. Nidhi, are you able to hear?
No, it's same here.
Same here.
Yeah, Pooja, your voice is cracking a little. Uh,
That actually starts with the day you have with the Indian Patent Office. It is hello.
yeah, sure. We'll come back to you, Pooja, for the next question once again. Your
Okay,
voice
I'll
was
try
cracking a little.
reconnecting because okay, no issues.
Yes,
I'll
yes,
try
please.
reconnecting.
Yeah. So, Daniel, if we apply at Germany, how long does it take for a patent to be granted after application?
Yeah, I will make this very short. It's the same in Germany as in Europe, where the average time until grant is 2.5 to 3 years.
Wow. And the tenure for which it is granted, is it the same 20 years?
Yeah, so in Germany and Europe, 20 years from the actual filing date.
So that's the same. So is it necessary for a company to be incorporated in this geographical jurisdiction to apply for a patent?
No, so in Germany and in Europe, any company, any natural person on this planet can apply for a patent. The only thing is, if you do not have a place of residence or business in Germany or Europe, you are legally required to have representation. So you absolutely need a patent attorney who can represent you.
So it's possible for entrepreneurs from outside Germany and Europe to apply using the services of expert attorneys there, correct?
Absolutely. This is the standard. What happens a lot, I mean, in Europe, the biggest filers are from the US and China. It's a very popular place for filing patents.
So for the interest of the entrepreneurs and the startups, MSMEs in India, I would like to have this question to Sri, benefits of patent protection with some case studies employer-employee perspective, business perspective, recognizing the IP within the organization?
Yeah, this
Anything
is
out of your experience?
this is a big list, Nathan. So I'll try to keep it short. If I summarize, patent can be a win-win across the chain. And once you file a lot of patents, you are actually building a patent portfolio. Now, once you have a large portfolio, then just like they say, strength respects strength, IP also respects IP. Once you have a fairly large portfolio, then the amount of people who try to come and what do I say, come after you for transgressing something is lower because it's potential that you also have a lot of things that they might be transgressing on. It gives you some amount of indemnity. And the other thing is when you have a patent portfolio, then it increases the value of your company as well. Let's say you're going in for funding as a entrepreneur. One of the things that a lot of friends tell me is that the first thing that gets asked is, have you patented what is unique about your startup or what is unique about your offering? Then the moment you say no, then you're almost telling that whatever you've done can be replicated by somebody stronger with more money power or with more marketing power, which means your uniqueness can easily be replicated and you can be taken over with somebody with better execution skills. And then if you're a slightly larger company, then you have a patent portfolio, then your valuation, let's say somebody is trying to buy you or you're trying to buy somebody, then you're looking at patents, though you don't put an exact number to it. Um, that comes into line. Or if you're trying to even borrow money, I've heard you can use your patent portfolio to decide how much line of credit that can be extended to you. Now that's at the business level. Now if you look at an employee level, uh, everybody who's working for you is looking at building careers. Now if they can file patents, then it really increases the value of their careers. Holding a few patents really is great for them. And then how to make it attractive for them? Do you have a rewarding system to recognize inventors within your company? Then suppose somebody comes up with a great idea, then how do you um, reward them for coming up with idea apart from helping them patent it or investing in the patent? So there is an entire set of rules that you can use or rewarding system that you can use. So the benefits of patents are across the chain. So there's 100 ways we can think about it. I'll just keep it short.
So on the same lines, continuing the same question, when the corporations are investing so heavily in terms of the research and the patent creation for the organization, how to make the business edge and commercialization benefit out of these IPs for the entrepreneurs and the enterprises?
So there, one of my mentors was telling me, if you really want a few patents that make a lot of money, then he was telling me 1,000, 100, 10, and 1, which means you need to increase the top of the funnel. And then there was, I mean, I can't name the patents, but there was one patent that uh, actually made a lot of money for one of the companies that I worked in, and that patent is still being talked about even after 10 years after its term expired. So, which means when you have a lot of patents, even one patent can bring you a windfall. So that way, it always brings you a business edge. And I covered some of that in terms of line of credit and line of credit earlier. When you are developing products, or if you're a company who has a few crucial patents that are needed by others to develop products, then you are sitting on something that can be cross-licensed very well. You can make a lot of revenue out of it. There are multiple ways to leverage that. You can have something that disrupts others. You can have something that everybody needs, but you're the only one holding the patent for that, and there's no easy workaround. So the kind of patent you hold gives you a lot of business edge.
Perfect. So coming back to Daniel, Daniel, if I have an invention which is registered in Germany, do I have to re-register it at Europe?
So you don't have to, but you can. So if you get a patent granted in Germany, it's of course only valid in Germany. So in the German jurisdiction, on German soil, if you want to say. And with a European patent, you can potentially get protection in 38 countries in Europe. And this is not only the European Union, it's also countries like Switzerland, Turkey, or Norway, which are not part of the European Union. So it's a much broader geographic area you can obtain. And of course, you can then get also a patent again for Germany, maybe with a different claim. Both is possible.
Perfect. And there is a participant question here in the same lines on the importance of registering a patent in countries other than your own home country. Your advice?
Yeah, so I mean, it all depends on where is your market. So where do you sell your products? Where do you manufacture your products? Where are the main markets of your competitors? And these are the questions you have to ask yourself. So and these markets will then determine where you should get protection. A patent is primarily a right to forbid others to do the same. So you might want to definitely consider the main markets where your competitors are, where they produce, but you should also cover the markets where you yourself sell products and produce yourself. So you should certainly consider other countries as well, especially when considering that startups of today are international from beginning onwards, from day one. So they should think about other markets, foreign markets also immediately.
So can I do international patents from my own country, applying it my own country patent office? Daniel?
So you're asking, I didn't quite understand it, the international patent process?
Yes. How to do international patents from my own country? Is it possible, or do I need to apply it overseas?
Yeah, so there is the so-called International Patent Application, PCT. It covers almost all countries on this planet. And this process allows you to save the filing date of your invention for all of these countries. And you then decide how quickly you want to go to these countries. If you are a resident of India, by legal requirements, you have to get a written permission by the patent office, in particular by the controller of patents, before filing a patent application outside of India. The reason for this rule is just that the Indian government, of course, wants to check if your application, or has the possibility to check if your application contains any subject matter of national interest, like weapons or security technology. So you just need to get this permission by them, and if they give you the permission, you can file in any other country, including the international patent application. But the international patent application must then be filed with the Indian Patent Office if you are a resident in India.
Great, thanks. And Shri, coming back to the use and utilization of granted patents at global level.
So I think for this question, maybe Andy, you can pitch in a help as well. I think within the companies that I have worked, which have mostly been US majors, most of the patents were filed either in US or sometimes in EU. And then the product, I mean, the patents are freely used in the products which are developed across the world. So I've not encountered this scenario much. Maybe in companies where you deal with business to consumer kind of products, that's where Daniel mentioned based on what markets you pitch for, then you'd actually be interested in whether you're cross-licensing those patents across the countries, or is there a conflict of patents in some geographies. Maybe somebody else on the panel also can add to that.
Maybe Pooja, you can add. And one more question, specifically schemes that are available for startups and MSMEs, Pooja.
Answering to the previous question which you were asking regarding expedite examination and the schemes which you are adding the question right now, I would like to give a combined answer to both of the questions. The thing is that startups came into India with the concept of Make in India when it was being introduced by our government. So startups needs to be focused more, and moreover, apart from this, we also are having our MSME Act, which allows small, medium, micro, enterprises based on their turnovers to work in India and to get certain facilities. There are so many exemptions given, so many facilities are being given to them so that they can do really well in the market. And that is why patent office has also amended their rules and regulations. Earlier, as I previously said, the fees were really different for each of these categories. Now it is being brought together under the category of natural person, where the fees is really minimal. As I previously also said, 1600 is the fees of basic filing, and if you go for what is that examination process also, then it will add up around 4000 more. So at a mere cost of 5600, these startups and MSMEs are getting the benefit to file in our country. That's a very less fees according to me, because there are other things also which add up when you are going for like commercialization and other formalities. Comparatively, it is really less. So this is the one thing. Apart from that, as we are seeing, the working conditions in the patent office is becoming tough with the huge number of patent applications being filed in India for the, of course, reasons, and that is why it has been advised that expedite examination could be done. Now earlier it was only startups and only PCT applications which were being filed in the country, and assigning India as ISA were only allowed to get the facility of expedite examination. Now expedite examination is something where the examination process takes up really fast. Within a month you get the report, and based on how fast are you responding to the objections raised by the patent office, sooner you will be getting the grant. We have a record of around 60 to 70 days under which a patent was being granted, so that is also a possibility here. Now
So
as
I
the amendments
understand.
are being done.
Yeah, sorry to interrupt. I understand there are a lot of opportunities for businesses, and for that they can freely approach your
Of course.
offices in their geographical locations and get the benefits. It's not that
Yeah.
there is a big barrier in
Yeah.
between. Things are pretty much visible, and things are available on the website as well, the government
It's really
websites.
transparent now. Yeah, true.
So thank you so much, Pooja, for that insight. Sri, a key advice from your side to new innovators.
So for innovation, I think one of the things I can share is don't consider innovation as something accidental. Innovation can be deliberate, and if you actually search for systematic innovation techniques, there has been a lot of work done across the globe to capture ways in which people think, come up with ideas, and convert them into techniques and frameworks. My own belief and experience has been that if you pick these up, it actually helps you think of a problem space, narrow down, and innovate at will and come up with innovations at will. So, innovation is incidental, not accidental, is what I would say.
Thank you so much. That was really helpful and motivating for all the entrepreneurs. So we have talked about registration, verification, use, commercial exploitation. Daniel, there is a lot of things going around in the infringements phase as well. So in case of a third party infringing a patent, how patent litigation proceedings work?
Yeah, thank you, Nitin. This is, of course, I could talk an hour about this topic, and we don't have the time, so I will really limit it to maybe give you a feeling about this. Germany is one of the main litigation places on this planet. We have 1,500 litigation cases per year, which is much more even than the UK or France has. So we have many cases here, and have developed huge expertise at the judge's side. So how does it work? Normally, you would start with a warning letter where you contact the potential infringer and, of course, try to settle the case by saying, yeah, if you sign this contract with when and stop producing this product when it's fine, and you have to pay a contextual fine if you don't do it. If you don't find an agreement and act quickly within 1 month after you are aware of the infringement, you can pursue what is unique in Germany, again, the so-called preliminary injunction, which is a very fast proceeding to get an injunction. And but you have to be quick within 1 month and show the urgency. For example, if you want to get a product on the fair removed, stuff like that, the infringement must be obvious. The right must be clearly, or there should not be any serious doubts for the validity of your intellectual property right. Things like this, and these proceedings sometimes even happen the outdoor proceedings. And once this is over, you then must pursue the main infringement proceeding before the district court in first instance and second instance, and this main proceeding takes 2 years. And so it's a longer process, but before that you have this preliminary injunction, quick proceeding, and yeah, this is in a nutshell how it works. And the party which is losing has to bear the costs.
Great. Thanks for the insights, and this gives us an open thread for the upcoming session, what we need to plan regarding the commercial exploitation and infringement. So in the interest and to respect the time for all the participants, we'll have to have a hard stop here. I would invite Daniel to please come forward and propose a formal vote of thanks on behalf of TiE Germany.
Yeah, thank you, Nitin. It's now my honor and pleasure to give you the closing remarks. I was thinking of what to say, and I think, of course, the starting point is the pandemic. So the pandemic has, of course, shown us that we're all interconnected on this planet. And in the same way, doing business and developing technology also requires interconnections and collaborations worldwide. In contrast to the past, the startups of today, especially the ones we know from India, are international from day one. And we do not stick only to the home region, but rather reach out also to foreign markets. Similarly, developing a technology, new technology, involve multiple stakeholders. I think a great example is Industry 4.0 and IoT, which spans all kinds of traditional technologies like mechanics, physics, medical, and biopharma. And here, startups reach out to bigger companies, established companies, and vice versa. So in such a collaborative international environment, I think we have discussed today that intellectual property rights are safeguards for all stakeholders to give incentive for innovation, to protect innovation, and to protect market entry and make sure that your innovation doesn't get diffused and lost to third parties that are not involved, and that you have a possibility to put on file which of the collaborators contributed how and what. And this is what intellectual property rights provide to you. And I think this is a big benefit. And this benefit of this international collaborative environment, I think we have shown today by this IP webinar, co-hosted by our buddy chapter and fellows from TiE Nagpur and TiE Germany, 2 places which are actually spaced apart more than 8,000 kilometers. And I think this shows a nice way that we can do good things and work together globally. And we also need to do this in these times. So dear audience, thank you very much for listening and engaging. And if you have any questions, of course, feel free to send them to the panelists and or the organizers. Thank you very much.
Over to you, Nidhi. Nidhi, you are muted.
I'm so sorry. So thank you so much, all the eminent panelists, for the wonderful insights you have shared today. And the recordings, thank you so much, all the charter members, associate members, and the non-members who have joined across the globe. And the recording for today's session will be available at TiE Nagpur YouTube channel, and it will be also available with TiE Germany ED with Manjari. So thank you so much. And if you have any questions and queries regarding today's session, if you have any further clarification or anything else you wanted to discuss with the eminent panelists, so please do reach out us. I'll be available on ed@nagpur.tie.org. Thank you so much. Thank you, everyone.
And feel free to join us back on 30th of this month. We have a session on supply chain and disruptions and innovations in supply chain. So that is jointly hosted by TiE Nagpur and TiE Ahmedabad. 30th. Stay tuned. The information will be shared by Nidhi on an email to everyone.
Thank you.
Thank you all.
Thanks, everyone. Looking forward to meeting again in person soon. Thanks. Bye-bye.
Thank you so much.
Thank you everyone. Goodbye.
Thank you, Nitin.
Thank
Bye-bye.
you. Thank you.
Thanks, Chris. Thanks for joining in early morning.
No problem. Congratulations. Good job.